Hello and welcome to the News Minute. Last week, the Supreme Court had delivered a landmark judgment that has come as a huge shocker for the office of governors across the country and also to the union government. To talk about this, I have with me Mr. P. Wilson, who is a member of Rajya Sabha and also the senior counsel, the man who mounted this legal challenge. And for the first time in the country, 10 bills have been passed without the signature of the governor. Before I go across to him, here is a quick reminder. News Minute, News Laundry and News Minute Tamil, we are a complete ad-free platform. We are not dependent on government ads or ads from political parties. We are dependent on you. So if you like our work, do become a paid subscriber of the News Minute and support independent journalism. So thank you so much for talking to us.
Thank you.
It's a huge victory for the DMK, the party that you belong to, and also, for you have been like mounting a legal challenge in this case, going after the governor for a very long time. On what basis did you approach the court? What was your basic prayer? And how big a victory is this for the DMK government?
It's actually a path-breaking judgment and a landmark judgment. It's a great moment in the history, and particularly after the constitution has come into force, the first 10 bills which has become act even without the assent of the governor.
This has never happened before, right?
Never ever happened.
So I think all these governors will be in shock.
Certainly, they are in deep shock. This even gives thinking whether at all you should have a institution like governor. The institution of the governor, because they do the arm twisting, they sit over the bills indefinitely without giving assent. So therefore, now we have a case where the Supreme Court itself has interfered and has given its seal of approval and an order, a declaration that it is deemed to have been granted assent. So therefore, time has come where the governor's office nowadays are felt like a liability, and whether it is all required. You asked me one question, what was the prayer before the court? When we went to the Supreme Court in 2023, there were 10 bills lying idly with the governor's office, and more or less 3 years have gone. So therefore, our prayer was that the governor should take immediate action on the 10 bills. So that was our prayer.
The governor should, provide his assent or withhold the bills or send it to the president. These are the three things that the governor can do.
That is what found in the Article 200.
200. But the governor was not doing anything.
Not doing anything.
So you were forced to go to the court seeking a direction so that the governor can act.
Exactly. The three ways which he has got at the first instance, either to approve, give his assent or withhold his assent, and or he can even refer it to the president at the first instance. So he never did, before we went to the court. Therefore, we went to the court with this prayer.
And you went to the court with a prayer and you kept changing the prayer.
Yeah. So when we filed, this was a prayer. But the governor made our, writ petition infructuous at every instances. Like first time when we went, he saw to that the bills are withheld. And then he informed the court that nothing is there. My table is clean. This was the word exactly they used before the court, meaning that the writ petitions have become infructuous. The court doesn't have any lists to issue an order.
So there is no case before the court to issue an order.
That is what they thought and they meant.
Okay.
But what we did is at the first instance, when the notices were issued and when he withheld the assent, immediately our chief minister called for a special sessions and the bills were represented and sent back to him. So by the time when the case came for the next hearing, the Punjab governor case also, the judgment was issued by the Supreme Court, wherein Supreme Court made it very clear, if it is a second time bills have been reenacted and sent, the governor had no option than to give assent. So when the matter came up for hearing, the Supreme Court said, look, this is the second time they have reenacted and sent to you. Kindly go through the Punjab governor's case and advise your client. So governor has no options So this was the statement made by us and even the clarification issued by the Supreme Court. But what he did is this time, instead of giving assent, he wanted to wriggle out from the situation. He wanted to overreach the Punjab governor case as well as the court proceedings. So this time he referred the bills to the President of India.
So you also mentioned a very interesting point. Just before the case coming up for hearing in the Supreme Court, the governor will withhold his assent and send the bill. Instead of sending the original bills, he will send a Xerox copy. What does that mean? Like, what was the governor's office even thinking by doing something like that?
There is a saying in Tamil that when you hide comb, the marriage will stop. That method, I think the governor would have someone advised him. So he thought that if he doesn't send back the original bills, the assembly cannot reenact it again. So therefore he not only withhold the assent, he kept the original bills inside his cupboard under lock and key. And he sent back only the file stating that he withhold the assent.
Is this even a strategy? If you were a legal advisor for the governor, would you advise him to do something like this?
See, law doesn't expect that. The constitution doesn't expect that you have to send the original bills back. This is not a civil court where the originals have to be filed and marked. The intention of the governor is very clear. You have written in the file and someone has taken a Xerox copy on the original bills where you have written that you are withholding the file, and that Xerox copy is also enclosed in the file. So this was an argument put forward in this case. The argument of the learned Attorney General was, look, we have not sent back the original bills. Therefore, what the assembly did second time is, it's a first enactment. First time they have enacted. So this entire case will fall under the first proviso, which means the governor had three options. So according to the governor, since it was enacted at the first time, that governor's actions of referring to the president, it will not stand to attract the second proviso. Because the proviso clearly says that if it is sent...
the first time a bill is enacted and sent to the governor has the option of giving his assent, withholding his assent, and then sending it to the president.
Exactly.
So now the governor thought that this could be a strategy, not sending the original bills,
Yes.
giving the Xerox copy,
Yeah.
and saying the assembly does not have the original copy, so there is no reenactment.
Reenactment, exactly.
So basically he is trying to say that the second time when the bill was reenacted, that will be considered as the first enactment. First time. As a new bill, it has been enacted and sent it.
And that is what he set up a case that because this original bills were not sent, that cannot be construed as a second time enactment. So that was his argument before the court. But what we did is, by the time this argument was made, I came down to Chennai. I called the chief secretary and the law secretary, and we got the whole of the files, and we found that in the file there is a clear indication that his intention to withhold the bills. And there are Xerox copies of the bills on which he is, that endorsement is also found. So I placed it before the court on the last concluding date. Look, this intention of the governor is very explicit and clear. What constitution requires is the intention of the governor. So the intention of the governor is proved by his endorsement in the original file as well as a Xerox copy is there. Is he disputing that it is not a signature, or is he disputing that there is no withholding of the bill? So when his intentions are made known by way of a file, and when the file comes back to the legislature has all authority to reenact it and send it to the governor, in which event this is a second time reenactment, and therefore he has to compulsorily give his assent because of the Article 200. So that argument was accepted.
So basically the governor was trying to subvert the entire process.
Exactly.
And he was trying to tell the court that what he was doing is right by withholding or hiding some crucial facts.
Exactly. He thought that if the original bills are not sent back to the assembly after he withholds assent, assembly will become handicapped and powerless. It's something
without the bills, they
without the
cannot.
bills, I don't know. The second thing which setback, I could even say setback is, every time when the matter comes, they will come out with a statement saying that our prayer becomes infructuous because of the
Some action has
actions
been
has
taken.
been taken. One of the important thing is that when we second time the bills have been reenacted and it is waiting for the assent, the Punjab governor case has come, judgment has come. We are submitting before the court that let him take a decision because the judgment is there. Supreme Court also records that, and Supreme Court says, look, we have given a judgment in Punjab governor's case, please take a decision. This is the second time. So they take adjournment. And next time they come and say that, we have sent this bills to the president and our table is clean. And this time, the Supreme Court was a little bit not happy with the way the governor did. By that time, the Ponmudi case also, the judgment in Ponmudi's case, where, the first time the Madras High Court, after holding guilty, the disqualification set in, and that's why he lost his MLA and the ministership also. And he knocked the doors of Supreme Court. Supreme Court has granted interim orders, which will virtually the disqualification has been removed. So when the Honorable Chief Minister advises the governor to conduct the oath ceremony function, but the governor refuses to do that. So we have to knock the doors of the Supreme Court. In this case, we made an application and we told the Supreme Court that governor is not doing this. And you all know that Supreme Court came down heavily. The Honorable Chief Justice said that if you don't do it, we know how to do it. And gave him a 24 hours time. And it posted next day. Thereafter, he performed his oath ceremony, and that's how Ponmudi minister, he became a minister. One more instance is the Honorable Minister Sendil Balaji. Governor, he dismisses him in the morning. He writes a letter to the Chief Minister saying that he is dismissed. Thereafter, in the night, he will write another letter to the Chief Minister saying that you please treat this letter as kept in suspension. And then he's moving Attorney General for necessary advice. So all this was shown before the court. The saddest part is all his action, was never had the aid and advice of the Council of Ministers. Normally, the governor can function only with the aid and advice of the Council of Ministers. That is how the scheme of the Constitution is. He can't act independently. Even the Supreme Court said that you don't have a veto power. At every action, the governor should have the advice of the Council of Ministers. So the first instance did not have the aid and advice of Honorable Chief Minister and his Council of Ministers was to give assent. The second time also made it very clear that you have to grant assent. So despite that, he, in derogation to that, he forwarded to the president. The last important thing is what he did is he writes one letter to the president to withhold the assent after forwarding the 10 bills to the president, which he should have not done that. He is writing independently one letter to the president asking the Honorable President to withhold assent.
Okay, that's not the governor's job.
That is not the governor's job at all.
The governor should refer the bill to the president.
That's all.
And that too, he can do it at the first instance.
That's all.
And the second instance, he sends the bill, which is wrong. And then he writes a letter to the president saying, don't
grant assent.
Don't grant assent. Okay.
So therefore, you can see how crude the governor was behaving. That is why the court felt that there are no bona fides in his contention, in his actions. And every time they wanted to overreach the court proceedings and something unknown to the constitution. Who are you? Where is your power? What was the constitutional makers' intention when they brought this post of a governor? They thought you should be a friend, a philosopher, a guide. You act as a bridge between the government and the union government. But the manner in which you were acting, arm twisting, it's nothing but frustrating, and really they want to bring a deadlock to the legislature.
So the governor was not only frustrating the state government but also the court.
Exactly.
With his actions. And
Exactly.
that is one of the reasons why the court came down heavily on the governor.
Exactly. This is a unique type of case where the court had come across this type of behavior of a governor. One thing is the decision as to how long can a governor decide to decide on the bills. Whether the power of the court is there to fix time limit for the governor. The other issue is all his actions. You can see the action one after another. The intention of the governor is only to frustrate and overcome the proceedings, and also to see that the court doesn't pass any order.
So, any order. But what does this judgment mean to the people of Tamil Nadu, for the state?
Exactly. Now, this is one aspect. I've been telling you the behavior of the governor. Now, the larger issue is, can the governor sit over the will of the people? The bill is nothing but, it's an expression, the people's expression that is lying before him. It is a living document. The people elect, send their elected members to the assembly, and the will of the people prevails by virtue of enactment, legislation, and that bill is sent to the governor. Can he, thrash it just like that by keeping it or putting it in his cupboard? So that is what the court felt, that look, elected people have only 5 years time. Within the 5 years time, for 3 years you are keeping them in your safe custody, in your cupboard, and you don't take any action on that. And that is why it made the court to analyze all the judgments. We had placed before the Honorable Supreme Court the debates, constitutional debates. In fact, we have kept all the constitutional debates where the constitutional makers felt that the expression as soon as possible, which made the constitutional makers to bring an important duty on the governor to clear these bills as early as possible and not to sit over these bills. Why time limit was not fixed? The time limit was not fixed because the constitutional makers thought that if we give some 30 days or 90 days time, then the governor or the president will take till the end of 30th day or 90th day for to act on the bills. They don't want that to happen.
Okay.
They want these bills to be cleared as early as possible, and that is why the expression as soon as possible is found in the constitution.
Okay.
So we had placed before the court that this expression is because of the debate made in the Constituent Assembly. Apart from that, we also placed Sarkaria Commission's report, Punchi Commission's report, where they would have gone into all aspects and fixed a time limit. I would tell you at this point of time that the Supreme Court has referred to memorandum where that the Home Ministry itself would have framed guidelines for the President to act on the bill. A timeline has been fixed by the Home Ministry. So therefore, this 3 months time and 30 days time, you can't say some extraordinary constitutional issues have come. Therefore, this judgment ought to have been given by 5-judge bench, a constitutional bench. It is all what is said in the constitutional debate, the judgments of the various at a various point of time by the Supreme Court and the Government of India memorandum. The Supreme Court has given the timeline for the governors to act. And if you don't act within this timeline, the ultimate sufferer would be the people. And
So basically, the argument that some say that the governor should not, the Supreme Court should not have fixed time, because the Supreme Court is, taking up things in their own hands, and they are like, it's a case of judicial overreach. All that argument is not acceptable.
it is not a judicial overreach. When one organ fails, one organ of the constitution attempts to frustrate the constitutional requirements, the other organ will rise. That is the beauty of the constitution. You know, the power is vested with three organs: executive, judiciary, and legislature. Now here, executive is acting in defiance to the constitution, in defiance to the court orders. Therefore, the third organ, namely the judiciary, it raises up to this call and says, look, you are not acting in accordance to the constitution. I will declare it as it has got the deemed to assent from you. And that is why the deemed to have assent is being granted by the Supreme Court. And in my view, this issue was also argued before the Supreme Court. We had produced a Perarivalan's case where the governor refused to act on the aid and advice of the Council of Ministers to remit the sentences and release Perarivalan. And Supreme Court said, look, you don't grant approval to this file. You don't sign the file. I will open the prison and let Perarivalan free. And that was the order.
The court used their inherent
Article
powers.
142.
142, yeah.
This situation, it is left to the discretion of the Supreme Court. So the constitution cannot go to a dead end. It is a living document, living organ, and it has to see that it answers at all situations.
Did you expect that the court will use its powers, Article 142, to grant assent?
We had all the faith in the constitutional courts. We made all the arguments, we placed all the materials before the court, and we prayed for it.
And there was a prayer. People think that, okay, there was no prayer from your side to fix a timeline or to, invoke Article 142.
Everything is gone by records, and everything was argued and prayed for. This is not a civil court. We are dealing with the fundamental rights and the powers of the governor under Article 200. Especially, it is affecting the people of the state. This is not a issue starting and stopping with Tamil Nadu. Many of the states have queued.
It also has all India ramifications.
Exactly.
Right? So, what does it mean for the country?
Yes. See, by the time when Supreme Court was delivering this judgment, already Kerala has knocked the doors of Supreme Court with the same prayer. We had the Supreme Court had seen the case of Telangana and the Punjab and even the West Bengal. So it is not something new for the Supreme Court is facing with these types of cases. So therefore, the Supreme Court order, this judgment, certainly sends a clear signal to all the governors. Look, your duty and responsibility under the Constitution is that when the bill comes, you have to necessarily take either of the three courses, either at the first instance or at the other instance, whatever that is found in the Article 200, within this time limit. And the time limit has also been given by the court. So if you fail in that, then the states have liberty to knock the doors of the Supreme Court. So not only the governor, if the governor forwards under Article 201, like at the first instance, that also Supreme Court is making it very clear. Look, at the first instance only you had three options. At the second instance, when the reenacted, you had no options at all, except in an extraordinary situations where they have clearly said, like when the bill requires the assent of the president. So they have extracted a few sections also, and even the few articles also, and even Article 201 second proviso, 200 second proviso. So therefore, under these circumstances only, even for the second time, you can only reserve it to the assent of the president under these circumstances. Otherwise, you have to necessarily give your assent when the bill has been reenacted and sent for the second time.
Okay, so far what we have seen is a pattern. The governors were operating in a gray area of Article 200, which says as soon as possible. Like you said, as soon as possible is as soon as possible, but for the governors,
As
the
soon as
language has
possible.
been interpreted in a different way. As soon as possible. Okay, I'll take a call whenever is required. So now with this judgment, do you think that the state governments have been empowered? The governor cannot play their old games of behaving differently in opposition ruled states.
Certainly, ultimately, it will benefit the party which has come to the power, which has promised the people that they will bring welfare measures and changes to the government. And therefore, every elected government will have an intention to bring a popular legislation which will really benefit the people. And now, the governor cannot play with the powers under Article 200. And see, who are the governors? They are the agents of the union government. And this happens only particularly in the non-BJP governments, where they are not in line with the BJP, and therefore they use the governors to somehow arm twist and scuttle, or they choke the assembly, and see that ultimately this government doesn't do anything for the people, and ultimately they will say that the government has come here for 5 years and has not done anything. So therefore, this victory will certainly send a good signal, and a signal that cautions all the governor that if you don't do your duty within the timeline, the states are at liberty to come to the court, in which event all your malified actions will be exhibited before the court, deliberated, and ultimately you will also get a clear report from the court. That is the
So
message.
their actions will come under scrutiny.
Exactly.
So now is this a warning signal or a warning for the governors who have been operating out of the ambit of law?
Exactly. When SR Bomai case judgment was delivered by Supreme Court, the Supreme Court put an end for indiscriminate dismissal of the governments because of the reports of the governor. So therefore, earlier to that, the governors were acting as per the dictates of the union governments. Now this judgment puts the governor and the union government at fix that hereafter, if their actions are so malified, and then it can certainly brought before the court, and it is a justiciable one. The court has clearly said, if your assent is not in accordance with the constitution and not in accordance with the judgment of the Supreme Court, certainly it is justiciable. If it is justiciable, certainly all the conduct and actions of the governor can be exposed in the court of law, and ultimately they are subject to judicial scrutiny.
Sir, the office of the governor over a period of time, you have seen that there is a lot of politics. And after 2014, what we are seeing is that out and out it's become political. Right? In opposition ruling states, the governors are behaving differently. In BJP ruled states, the governors are behaving differently. Do you think that, do we need governors? Is the post still relevant?
Exactly. See, our Pere Ranger Anna, he said it's just like a beard for a goat. Do the goat require a beard? So, therefore, this post of governor, is it required? If you see the scheme of the constitution, framework of the constitution, the duties and functions of the governor, as I said earlier, what the constitutional makers thought is, like there will be like a brother who will be advising the government. There will be like a bridge between the state and the central, and there will be like a friend, philosopher, and a guide. But the days have come that we see them, that they have been specifically sent to scuttle or choke the government.
Choke states.
Exactly, the states where the non-BJP governments are ruled. So therefore, overall, I think this is an office of liability. You don't require so much of, why do you require such 100 acres of land? Why do you require 100 employees working under them? Why do you require another estate at the Ooty? Why do you require budget for the separate of an office of a governor, ultimately they are not there to help the people or help the government. And what is that you are contributing to the governance, good governance? Nothing.
The governor is doing a lot of things. He is giving us news. He is walking out of the assembly.
That is all
He
his
is withholding bills.
that is all his personal ambitions. This is not a place where you, at the cost of the people's. See, ultimately you are taxing the people. That money which you are spending to an institution can be usefully spent and be fed to the poor people, poor children. So time has come where these functions, assenting and all, can be given to the speaker. If the speaker thinks this has to go to the union government, he is aid and advice. Ultimately, we know, see, the constitution has given a clear picture: list 1 subject, list 2 subject, list 3 subject. If the speaker is advised that this bill falls under list 3, he will send it to the union government. What is required for speaker to decide when the constitution is very clear and he has to act on aid and advice of the government? And another thing, Article 356, if there is any law or a problem, there are many intelligent agencies working. They can give. That can also be ascertained by any independent agency. Why do you require an institution? Ultimately, it's a burden and liability on the people.
But both BJP as well as Congress, they don't want to give up on this institution. They still want the governors, and even during the Congress regime, the governors have been, governors have been doing things out of, violating the law or trying to frustrate the state government, trying to choke the state government. But if at all the government wants this post to continue, what are the changes that you think should be made?
Yes, in fact, I myself, as a member of parliament,
Yes.
brought private member bills.
Yeah.
The appointment of the governor should be made in consultation with the chief minister.
That is one of the bills, the private member bill
private
that you
member
moved.
bills. I even introduced a bill which will take away the immunity of the governor, because governor goes, he makes statement which really affects the people of the state. His statements,
a statement in the sense, defamatory statement.
defamatory statement.
Okay.
He even goes to the extent of saying change the name of the state. Many things. I can say he's embarrassing the government. I'm not saying in isolation to the present governor, but if you see as a whole. So this immunity, unnecessary immunity, is given under Article 361 for the courts, to take any action against him. That immunity has to first of all be taken away. He has to see, he is a servant of the Constitution, I would say, with conviction and assertion. Every constitutional authorities, including me, I am also a member of parliament. We are serving the people. We are the servants of the Constitution. Constitution is supreme. So you are accountable to the people. You are at the expense of the people's taxpayers' money. So therefore, you should come there and you should spend every minute of your time only in furtherance and welfare of the people. Therefore, this governors, if they are going to be sent and the post has to be retained, one, let it be appointed. Let him be appointed after getting the approval or
in consultation with the state government,
chief minister. The constitutional immunity should be taken away. Number 3, very important thing, I have also made this as my private member bill amendment. Let us fix the qualifications for a governor. First of all, a governor should know the Constitution. You cannot send a person who is ignorance of the Constitution. He should know what is Constitution, number 1.
Which category does R.N. Ravi fall into? A man who knows the Constitution, a man who doesn't know the Constitution?
I can say you can wake up a person who actually sleeps, not a person who pretends to sleep. So therefore, let him know the Constitution. The other disqualification which I proposed in my private member bill is that no person who has hold a civil post, the post in the government of India, should not opt for this governor post. A person, I will say a retired judge or a retired bureaucrats, they should not be given any post because there should be a cooling off period. This cannot be become retirement benefits.
Post-retirement.
Pre-retirement works. For a pre-retirement works, they should not become a post-retirement benefits. That's how R.N. Ravi would have been benefited. See, first of all, we should not allow the bureaucrats to have this post of a governor at all, because the three limb of the government, three different fields of the organs of the governor, they should be separate. When you are going to lure them with a post after the retirement, but they have to obey your dictates, then certainly they will do all sort of illegalities, and they will try to get the post retirement benefits. So that should stop. You should not allow any bureaucrats, even I would say the judges of the High Court or Supreme Court, to adore to this position. There should be a freezing point, and that's how I have brought in certain disqualifications. And why not a good professor? We had Abdul Kalam
as a president.
So you can have you can think aloud of a good persons.
There are a lot of people from ISRO, people from Tamil Nadu.
Good background, well qualified. And not a person like Mr. R.N. Ravi. He has set a bad example for all the governors. He has, in fact, all the reputations of the post of the governor is being affected. But R.N. Ravi, I can't say he's the only governor. There are instances happening in Kerala also, in West Bengal also, in Delhi, in Telangana, in Punjab. So therefore, time has come where the constitution has to be amended, the parliament has to step in, and how for every post you have a qualification. You kindly see what is the qualification of a governor. It's only an age. That is enough. So time has come where the qualification of the governor should also be spelled out, and the disqualification should also be brought in. We should not allow any bureaucrats to go into that post at all. We should not allow any even the retired judges also to take that positions. So therefore, this would be my suggestions. And so far as if they want to retain the post of the governor, but DMK has been propagating and been telling everywhere that this is an unwanted post.
Okay. My last question to you: do you think R.N. Ravi should resign after such a judgment?
Court has held him that all his actions are without any bona fides.
Okay, this judgment, do you see this judgment
Yes.
as an indictment?
Yes, indictment.
Governor's action and
Exactly,
the union government?
It's an indictment.
Union government?
It's an indictment both to
Okay.
both. The union government clearly knows at every point of time, including when the cases were pending, particularly when the governor is doing an illegality by forwarding the bills which has been sent to him second time to the president. The union government has advised the President of India to withhold the assent. What do you mean by that? President of India doesn't act independently. She acts under the aid and advice of Council of Ministers for the Union. The Council of Ministers for the Union includes the Prime Minister and the other cabinet ministers. So what do you see from this? So therefore, this action of forwarding the bill by the governor to the president, and the president being advised by the Union of India, all the actions have held to be illegal, unconstitutional, and has been set aside by the court. Therefore, this is not the way the union government should also treat the state governments.
Right, sir. Thank you so much for talking to us.
Thank you.
Pleasure talking to you.
Thank you.